Lawyers of Reddit, what was your "oh now you fucked up" moment? Unfortunately, my best story for this is from my own client. We had a client who was on the board of directors for a company and was being sued for allegedly not telling the board something. His part of the case was really only a smaller part of a larger and more complicated case. So while there were a lot of other issues in the case overall, the entire case against him specifically essentially boiled down to whether or not he told the board about X. I and few other attorneys spent an entire week, 9 a.m. to 5 p.m. or later, Monday through Friday, prepping this client for his deposition by going over every document in the case with him and explaining why it was important. On several occasions we reiterated that no matter what else happened in the case, as long as we can show that he told the board about X, he was fine. The day of the deposition arrives. Opposing counsel sits down and starts questioning our client. In the first 5 to 10 minutes of the dep, opposing counsel straight up asks our client what he told the board. Client responds, "I told them about Y. I told them about Z. I told them about A, B, and C," and says nothing about X. Literally the only issue in the case against Hi Monsieur. In 20-plus years of practice, it was the closest I've ever come to rage quitting on a client. You can lead a horse to water, but you can't make him say X. I was tangentially involved in a custody dispute. Dad alleged Mom was doing all sorts of things and he should have the kid. Dad's attorney grilled Mom for about 20 minutes on texts she had sent claiming to sell her prescriptions. She wouldn't admit it. Dad's attorney moved on and eventually ended with, "One more question. Where did you get the pills you were selling?" Mom responds without thinking, "Oh, my doctor prescribed them, monsieur." Dad had a smart lawyer and a stupid ex-wife. Years ago I worked in personal injury, and we had a woman come to us saying that she slipped and fell outside of a nail salon because they hadn't swept up the wet leaves outside the door. So we take the case, and almost immediately we get a call from opposing counsel saying he's going to courier us something important. We opened it, popped the disk in the computer, and right there is security cam footage of our client picking up the wet leaves, putting them on the sidewalk, and sitting down on them before calling for help. I have never face-bombed so hard. Needless to say, we dropped the case. Reminds me of those insurance scams where people would jump onto moving vehicles. A doctor testifying under oath that he deliberately chose not to inform a pregnant woman of a positive test result for a really severe genetic disorder, because he figured because she was a member of his church she wouldn't have considered aborting the pregnancy under any circumstances. A primary care doctor who received a complex and technical test report from a genetics lab and simply forwarded it to the patient, who didn't really speak English and wasn't medically educated. She testified that she performed the minimum required diligence, which is not what you should say, and expect a good outcome. WTF with that first one. Seriously, even if they felt like she wouldn't abort, it's still important for a parent to know of possible issues so that they could probably prepare physically and emotionally to care for that child. The child, in this case, was born severely physically and mentally disabled permanently. This outcome would have been 100% predictable, beyond a reasonable doubt, well within the first trimester. They would require constant and expensive care. As one of the authors who wrote about this case points out, the doctor who failed to perform his duty will not have to care for the child for the rest of their life. Had a bylaw officer harass me almost constantly for 8 months for violating bylaw. I had parked my motorcycle in my driveway. He ordered me to remove it, and tried to levy fines for the violation. He went after my landlord and tried to get me evicted. Eventually, I got a lawyer and filed a complaint. When asked to point to the bylaw I was breaking, he didn't even read it out, which basically read, * no parking or storing anything in a driveway other than an automobile, *. He seriously thought a motorcycle wasn't an automobile because an automobile is a car. When I hired my lawyer and showed him the case, he said, "I'm not taking new clients right now, but I'll make an exception because I'm personally offended that this is happening to you." Everything was thrown out, and I'm currently working on getting my legal fees and extra payments for all the harassment. This was in a custody dispute. Jury trial. We represented the father of young twins, and the mother wanted child support. The issue was that, for the past 3 years, they had been sharing the kids exactly 50-50. As in, he got a weekend, she got a weekend. One of them got Monday, Tuesday. The other got Thursday, Friday. And they split Wednesday. There was no reason not to have a shared custody order with each parent paying their own expenses. But she thought she could get more. So there we were. The thing was, she did not have a case. She kept taking the kids to CPS and child psychologists before the trial to make a reason why she should have primary custody. But we managed to get all of that excluded. So on the day of the trial, her big argument is that these kids have asthma. Severe asthma. The kind of asthma that requires special equipment. And the father is ignoring these issues. He's negligent. He's endangering the monsieur. She should have custody. The trial is generally going our way. She's not a great witness. She doesn't have any medical records to back up these allegations. And we have the children's daycare teacher testifying that she doesn't know anything about any special equipment or severe asthma. But the moment that sealed the deal came when the mother called her last witness. The last witness to testify was the children's grandmother, the mother's mother. The jury already knew that she frequently babysat the two kids, and that her apartment was often a drop-off location for the kids. The mother swore that the grandmother never smoked in front of the kids, and that her apartment was not a dangerous environment for asthmatic children. The grandmother was called last minute by the mother as a rebuttal witness. As she took the stand, the grandmother leaned over into the microphone and cleared her throat. Asterisk, asterisk, ahecchhhm, monsieur, asterisk, asterisk. It was a 2 or 3 second long expression of smoky phlegm, monsieur. I don't recall exactly what the grandmother said in her testimony, but I remember she sounded like decades of 3-pack a day smoking when she said it. After a half-hour of deliberations, the jury awarded primary custody to the father. He immediately started crying, while the mother sat motionless. It was a good result. Wait, was the mom the one that went to court because she was unhappy with the 50-50 split? Because if so, look how the turntables. Not a lawyer, but a law student. This was in a case that my professor showed us in class. Some guy was accused of something. I cannot remember what, but the judge spoke him free because there wasn't enough evidence he had done it. Guy said, "Thank you, judge. I'll never do it again." DA appealed and got him convicted. My phone rang in court and forgot to put it on silent. The ringtone was the Mortal Kombat theme song. When my client filed a restraining order against his ex and then asked me to leverage the restraining order just so he could get back with her. In our state, if you do this, you'll have to pay the other person's attorney's fees. Could you explain this a bit more? Sorry, I'm not very law savvy, so I don't understand how the guy could use a restraining order to try and get back with his ex. I'm not a lawyer, but based on you, throw RAA2B3C41's reply, I believe that the client took a restraining order out on his ex so he could use it to manipulate her into getting back together if he was willing to drop the restraining order. I was involved in a civil suit against an organization that allegedly allowed and attempted to cover up the sexual assault of an at-risk population. During a deposition of a victim, the opposing counsel began asking an aggressive line of questions, accusing the deposed of having been convicted of making false reports in the past, and convictions for forgery and identity theft. After our client answered with a simple no to about a dozen of these questions, opposing counsel became belligerent, eventually basically signaling that at trial he would be producing mug shots, as well as conviction records, as well as charges for perjury, and right about at that point he becomes ghost white. Pulls very close to his face what is clearly a photo he had in a folder. Looks at it closely, then shoves it back in and asks to conclude the deposition. He had pulled records on the wrong person. I later found this other person, and while their names were the same, the ages were more than 15 years apart. Did they at least look similar in age? I'm way past the cutoff for swing an R-rated movie without a parent, but I still get asked. This was a couple of decades ago, where info was not nearly as readily available as it is today. Certainly including photos, the date of convictions, etc. were believable that our client was the assailant. But from my recollection, they absolutely did not look anything alike whatsoever. One looked like a career criminal and drug user. Our client absolutely did not. Thank you so much for watching and have a good day.